So what's interesting, I think, is that actually the case for private defense is a piece of cake. That's really not what trips people up. Really, when people give you all these zingers about, well, what if this happens? What if this happens? You know, what if there's 18 midgets who are armed with broadswords and they jump off of a plane? And what happens is, a lot of the times it boils down to really what the issue is they can't get how private law could work. And that's really what the stumbling block is. And that admittedly is a much more difficult problem. But I think once you see how that system could work, just in terms of having society or the consensus emerging within a group of people to say who is the aggressor here, who's the lawbreaker, or what is the law, and how do we determine who's law-abiding and who's a criminal, that's really the hard part, to say how could you do that without some monopoly agency that arrogates it to itself the right to make such pronouncements, and then the rest of us just have to fall into line. If you don't have a single group vested with that authority to do that, it's a lot more difficult to understand, to just picture how could that work, because everyone just kind of automatically assumes you need to have such a single group with the ability to do that in order to promulgate laws. So, like I say, I think a lot of these issues that trip people up in terms of private defense or just private police forces and so on, it's really an issue of private law. So I would say keep them separate. They're different problems. There was one issue of how do we determine what property rights are? How do we determine who's a criminal, who's not? How do we determine what the lawful use of self-defense is and things like that? And then once you know that, then it's just a matter of people contracting that out. If you have the legal right to go use force to get your television set back because you think someone stole it from you, well, then it's to say, well, I'm actually a 98-pound weakling, I'm going to go hire someone else to do it. That's not really an issue. And you can totally see how, the market would be more efficient there if there was competing agencies hiring out burly guys to go get your television set as opposed to you have to go to the monopoly government that does that for you, right? So the issue is the definition of legal rights and so forth and what your redress is in case you think someone's violated your rights. That's the hard part. You get that solved, and then just enforcing those rules by having competing agencies trying to get your patronage, that's nothing. So let me just spend a few minutes then talking about this issue, how would private law work? Well, I think the conceptual thing is to separate out the enforcement of it from the decision-making, the rendering of decisions. And so there's a clue. When you say, what does a judge do? A judge gives his or her opinion on something. And that's now, how you hear reports about the Supreme Court. And he wrote the majority opinion and he wrote the dissenting opinion. And we use that term opinion to be associated with judges and what they do, but I think we just take it for granted. Say, oh yeah, that's a judge's opinion, but I take that word literally. I really think that you should consider it as a literal thing, that what the judge is saying is, in my opinion, looking at my knowledge of precedent, looking at my knowledge of the facts of this case and my intuitive sense of justice or whatever, I think the correct ruling in this case would be such and such. That's my opinion. And that's really all that a private judicial system is doing, is it's people who are experts in various types of cases. When disputes arise between people and they can't solve it on their own, they take that dispute to a third party. And how do they pick that person? In a free society, it's not because a bunch of guys with guns say, oh, if anyone has a dispute in this area, then you get assigned this person, and this person's going to tell you who's right and who's wrong. Obviously, that's not the way it works in a free society. In a free society, people can't decide, there's an argument. They then say, well, we can't work this out. Let's take it to somebody. And the person they're going to take it to is going to have a reputation for fairness and objectivity and knowing the law in that particular area. Right? So that's I think, the way 99% of judicial issues would be resolved in a free society, is that people would take it voluntarily. Both sides would agree beforehand to go to this particular person that they might call a judge. Nowadays, in our society, we would think, oh, that's arbitration. And that's exactly what happens on arbitration. Both people, if someone's going through a divorce or some business and an employee, the business fires the employee and the employee says, no, that wasn't right. You owe me wages that you didn't pay me. And the business says, no, we don't. And they can't work it out. They don't want to take it to a government court because it'll just take forever. And so they can both agree beforehand, all right, let's go to some arbitrator and just deal with this because we need to move on. This is costly for both of us to have this up in the air. We have to resolve this dispute. We're not going to settle it by arm wrestling. We're not going to settle it, by having a duel, because that's crazy. we're gonna, it's bad for business and also you might get shot. So what we're gonna do instead is take it to an arbitrator. And it's not that, oh, well then we're in trouble. Everyone knows that the arbitrators always rule in favor of the business. Well, no, that's not true, because if it were true, then the employees would never agree to that, right? So there is a market for an actually objectively fair arbitration process. So let me just give you some quick analogies, because a lot of people think that, no, that's impossible. What you're describing can't exist. But we see that sort of thing all the time in different areas. So like if you're talking about scientific journals, for example, how is it that good science is promulgated? And of course, if there's government funding and things, that messes it up. But in the original spirit, and how would it be in a free society, there wouldn't have to be just some group of people called the physicists, and then they get to determine who the other physicists are using force, and they have a monopoly. That's not the way it would work. Someone would come along and try to publish a paper, submit it for peer review and so on, and the other physicists in the field would decide whether they thought it was good or not. And it's hard to actually put your finger on who is determining who the right physicists are, who the best physicists are. You'd say, well, the people in the field are, but how do they get to be in the field? Well, because the other physicists let them in. So it's an odd process, but I think we can all agree, especially in a free society, it's not that physics would be arbitrary. It's not that the people who would be getting accolades and would be teaching at the top schools would be a bunch of fools and wouldn't know anything about the laws of nature better than the average Joe. No, those people would be experts in that area, and it wouldn't be arbitrary, and yet there would be no monopoly the way the government right now has a monopoly on judicial rulings. I'll just give you one more example. Especially in a free society, but even right now, who determines what words mean? Who defines words? And people might say, a very superficial answer would be to say, oh, the publishers of dictionaries, they define what words are. But no, they don't. If Webster's came out with a new edition and said that the word up, UP, means moving towards the floor, we wouldn't just all walk around saying, oh, I guess I was mistaken. No, we would say they put the wrong definition in. What are they doing? And if they did that a lot and we kept finding those mistakes, people would stop buying from Webster's and they'd go out of business. Right? So what the publishers of dictionaries do is codify the definitions that prevail in the community. Right? So they don't get to invent what the words mean, they just codify it. And then you could say, well, wait a minute, but then what's the role of having a dictionary? What's the point of having a dictionary in the first place if they're just writing down what we already know? And again, you see like these superficial things that might be objections to private law, but you can see in the case of dictionaries that that's silly. No, dictionaries serve a very useful function, because a lot of us don't know exactly what words mean, or we think we know what they mean and we use it in a certain way, and then you look it up and say, oh my gosh, I've been using this word wrong for 20 years, right? That's happened to me before. You use a certain word in a way, and because you use it in one sense where it works, but then you try to apply it somewhere else and you realize that actually it didn't carry over, because you'll look up the actual definition. So the point is, we collectively as English speakers know what those words mean. The community somehow knows, but yet not everyone is an expert on it. There are some people that's what they do. They specialize in knowing the definitions of English words, and they are the ones who write dictionaries. Or it's even more compelling in the case of grammar books or style books for writers. And you can look up and say, oh yeah, I shouldn't say firstly, I should say first when I start the sentence, or whatever. So the point is, there are rules of grammar. They're not completely arbitrary. It's not that you can just say whatever you want because, hey, there's no such thing as real language, or there's no rules of language. No, there are rules, but there's also a sense in which we decide what they are. The English we speak now is different from the time when Shakespeare wrote. So the definitions of words and the grammar has evolved over time. So there is a sense in which we decide what the words are and what the rules are, but in another sense, anyone who tries to deviate from that is an oddball and is violating the rules of grammar. Okay, so I think that's a good analogy in some respects for how private law works in general, that there would be people codifying certain principles, right? So there would be a role for people writing like theoretical books on this is the way the law ought to look in a just society. So, Rothbard could have a natural law approach. Utilitarians might put their views out. Other people could put different things. And then the judges would render opinions, would give opinions when cases are brought before them, perhaps drawing on those various strands that they think are relevant. And then the market would determine which judges got more cases brought to them. And they also would probably rely a lot on precedent and case law, because clients would want to have some inkling before they went into the case of how is this guy going to rule, right? That if if the company's having the dispute with the employee and saying, we think we paid you what we owe you, and the employee says, no, because you said you were going to give me bonus and you didn't, they wouldn't want to, if they went to an arbitrator and then they got in there and he said, okay, the way we're going to solve this is to see who can chug this beer faster. Go, right? They would be stunned. And they said, that's not the way you ruled on previous case. We thought you were going to rule on this the way, you know. So the point is, you would want predictability going into it. So it would be in the judge's interest to have standards, to say things like, these are the rules of evidence. You know, you can't use hearsay, or maybe you can use hearsay with these exceptions. So a lot of the stuff that we now, that if you go into law, the things that seem natural and just to us, there would still be a role for that. It's just the way it would manifest itself is the judge would have to provide a service to attract people so that both sides would be willing to submit to the judge beforehand, going into it.